Good morning, everyone. I would like to welcome Dr. Bharat and Suryavanshi, Assistant Controller of Patents and Design, Nagpur. On behalf of Maulana Azad Education Trust, YB Chavan College of Pharmacy, all the members of the management and faculty of YBCCP, I welcome Dr. Suryavanshi sir for the lecture on patents. And I request Dr. Jayaprakash Sangh sir to start the session.
Okay, thank you very much,
Over
sir.
to Jayaprakash sir.
Thank you very much, sir. So, I welcome you on behalf of YB Chavan College of Pharmacy. So, today's speaker, Dr. Bharat and Suryavanshi, I'm here to introduce today's speaker. Dr. Suryavanshi is working for more than 18 years in Central Government Office, in the Patent Office, Ministry of Commerce and Industry, and presently is working as an Assistant Controller of Patents and Design. So he has done his PhD from Swami Ramanand Tirth Marathwada University on bioefficiency and phytochemical studies of medicinal plants. He has completed his MPhil on plasmid profile of proteolytic lactic acid bacteria from Gulbarga University, Karnataka. He has published a number of papers in the national and international journals. He has delivered many lectures on IPR in the various parts of country. He was deputed for training at Tokyo, Japan for examination and IPR issues. One of the key highlighting feature of his overall career in IPR sector is he has given landmark decision by rejecting Pfizer patent application for arthritis drug, which was filed in India in 2015. With this short introduction, I am handing the session to Dr. Suryavanshi for sharing his views on IPR, patent, and design filing. Over to you, sir. Suryavanshi, sir.
Thank you, sir. Thank you so much. Good morning, all. I also welcome you all on behalf of Rajiv Gandhi, National Institute of Intellectual Property Management, Nagpur. As you are from pharma background, you might have filed many patents, design application, even though I'll throw some light on the IPR by sharing my slides. Are you able to see my screen? Anyone, please?
Yes, sir. Yes, sir.
Slides are moving?
Yes, sir.
Okay. First of all, I introduce my ministry where I'm working. I work under the Ministry of Commerce and Industry, Department for Promotion of Industry and Internal Trade. Our office is called as Office of the Control General of Patents, Designs, Trademark, and Geographical Indications. As you might have knowing, we are having different offices at different locations like Kolkata, New Delhi, Mumbai, and Chennai. We are having PIS that is called Patent Information System. Now it is called as Rajiv Gandhi, National Institute of Intellectual Property Management, Nagpur. We are having trademark offices in addition to 4. One is at Ahmedabad. Geographical Indication Office at Chennai. These are the pictorial view of our offices: Mumbai, Delhi, Chennai, and Kolkata. This is our training center. If you are not knowing anything about the IPR, please log on to www.ipindia.go.in. You will get all details of the different intellectual property rights. Again, this is an awareness program. I cannot go in detail with each intellectual property. Therefore, we're keeping many programs online, offline, or website. You can please check, as well as social media account like Facebook and Twitter. Log in and you will come to know what are the programs we are conducting. Join and take the benefit of that. Let us see today's topic, which is allotted to me, is intellectual property. What is intellectual property? By seeing my slides, you might have thinking that something which is product of mind is called intellectual property. Therefore, I have shown below means any kind of property that arises as an intellectual property. how it arises during discussion in the classroom, or you are in the lab, or you are carrying out research, or you are sitting alone or with your group of friends and talking on particular problem. So something which comes out of a human intellect or property that arises from human intellect is called intellectual property. For example, in December 2019, we heard about the coronavirus. At the time, we are not having any vaccine composition for that. What we did, we have started the research, not only in India, throughout the country. First of all, we studied what is coronavirus, what's the genetic material. Then we came up within a 1 year, in middle of 2020, Covaxin, Covishield, Sputnik. What is this? This is an intellectual property that is product of mind. Let us say another kind of example. Today we are having petrol and diesels. What about the next generation? May they have? May not. It's not sure because petrol, diesel is not a renewable source of energy. Therefore, today you are being pharma or chemist or micro or biotech or any kind of engineers thinking to produce biodiesel. It's an intellectual property. Really, if you are bringing in the form of product as an biodiesel or process of preparation of biodiesel, then definitely that's an intellectual property. I'll quote another example. We know paracetamol. As you are from pharma, if I consume today paracetamol at 8 o'clock, it takes 6 to 8 hours to reduce my fever. As you are coming with new formulation, improved formulation for paracetamol, which can reduce your fever within 2 to 3 hours, then that is you are showing therapeutic efficacy. It's an intellectual property in the form of medicine. It's intellectual. Same way, if you are developing process, that's an intellectual. So something which arises from human intellect is called intellectual property. Let us see what is the background of intellectual property. Property means our mind directly goes to the tangible form of property that we say, I am having car, gold, plot, flat, so I am rich enough. But there is another kind of intellectual property called as intangible form of property, that is intellectual property. In that, we are having industrial property, copyrights, industrial property, patents, designs, and trademark, geographical indication too. Let us see what is patent, how we can define that. Exclusive, monopoly privilege or right granted by the government to whom? For the patentee. For how many years? 20 years from the date of filing or from the date of priority for what? Commercial gain in consideration of the full disclosure of his invention as a territorial right, not worldwide. It means if you are filing a patent, you are getting the award in India only. You cannot say that awarded throughout the country because it's an territorial right. Still, many are confused what is discovery and invention. Discovery means finding or exploring something which is already existed. Discovery as such, no technical effect. For example, if I'm isolating some microorganism from jute industry, cement industry, or any kind of industry, the process of isolation of microorganisms is maybe I'm changing the media, pH, temperature. So the process of isolation of microorganism is patentable, wherein the microorganism as such what I am isolating is an discovery because it is present in the nature, just your discovery. But genetically, for modifying by using genetic engineering technology, definitely genetically modified microorganism is patentable. Again, if you are somebody is working on medicinal plants, then if you are isolating compound from some medicinal plants, like let us say Regacia tinctoria, then the compound as such is a discovery, but the same compound, if you are using as a composition for treatment of psoriasis, again it's an invention because you are claiming in the form of composition. So while doing your research or project or PhD research or any project of B Pharm, M Pharm to get a degree, please identify that whether you are doing inventions or discoveries. If it is invention, please go for the patent filing. What is invention then? When we can say that your research work is qualifying the definition of invention. Invention means a product or process. Many people ask us, sir, idea patent hota hai kya? Yes, idea is patentable, but idea should come in the form of product or process. Today I'm getting in my mind idea that I should produce herbal medicine for cancer. But until unless I produce in the form of composition, medicine, or lotion, it doesn't work. So my idea should come in the form of product or process. Again, it should be useful, novel, non-obvious, and not public knowledge. It means it should know. What we do during the paper publication, we check whether my research paper is published in any other journals or not. If not, then only we are going for the publication. Same way, if you want to say that your project, your research, what you are carrying out is a new or invention, then it has to qualify these requirements: newness, usefulness, novelty, non-obvious, and not public knowledge before the filing date. What is non-obvious? I'll tell you in the inventive step. Simple example is sharpener. Earlier, there is no sharpener. We used to use the blade for sharpening the pencil, but somebody has invented, that is C.A. Boucher. He got awarded. You are a scientist, but you are not an inventor. Until unless you file the patent, you get a patent, then you will be called as an inventor. So we know in the journals we have studied who has invented aeroplane, Wright brothers. Who has invented electric bulb, Thomas Alva Edison. Who has invented this AG. Now we have connected virtually, even though we can make this session as an interactive. Now I have shown you this example as an invention, even though scientists of electronic and telecommunication came up to the mobile phone. What was the necessary? Why they have gone up to the mobile phone? Anyone from students, faculty, or any others? Why they have gone up to the mobile phone to do and research? Already the technology was in the market in the year 1876. You know this telephone. You have seen in the old movies or anywhere which are there of any language also. The telephone was used in the movies, Hindi, Marathi, all movies they have used. Can anyone tell me why someone is thought of going up to the mobile phone? What was the necessary? Because this telephone is having two disadvantages. One, I cannot change from my cabin to my principal's cabin because it is connected at a particular point. Again, if I want to dial, 10 times I have to dial. It's very hectic, time consuming. Therefore, scientists of electronic and telecommunications came with the table phone wherein directly I can dial. Again, one disadvantage with that, I cannot change from my cabin to my principal's cabin. To overcome that, they got cordless phone, which is very long. We can take in the hall, kitchen, and in drawing room. To overcome that, we got the mobile phone. If you remember, in the year 2000 or in and around that, simple Nokia of silver color was more than 5,000. But now 1,000, 2,000 up to 40,000. What is this? Improvement of technology from 1876 to till today. From this, I want to convey one message that any improvement in the technology is also patentable. Any improvement in the technology is also patentable. Dr. Kant, I'm in lecture. I'll call you later. Okay? I'm in lecture.
Hello.
I'm in lecture. I'll call you later. Okay? Okay. So this is an example of invention. What we have done? Improvement over that. So improvement in the technology from AG bell to mobile phone. Same way. If you are developing any improvement in your medicine, composition, lotion, or process, or powder form, anything, if you are doing improvement, like earlier perhaps I have given an example that it takes 8 hours to reduce your fever. Now, if you are bringing the improvement that sits within 2 to 3 hours, it is reducing fever, then it's an improvement in the technology. Again, in India, we are giving improvement of technology also patentable. Like Nokia got patent, Samsung got, Apple got, every company is getting patent for that. Bluetooth. Earlier there was no Bluetooth, but now they have invented, they got the award, that is Job Hudson S award. Let us see another kind of intellectual property called designs. Design means shape, configuration, surface pattern, or composition of lines or color combination thereof applied to any article in the form of 2D, 3D, or both the forms. I have taken an example as an Bajaj iron box. You can check the iron box of different design which you are having. My comb is in this kind of design. You might have something design. This bottle design is like this. Somebody bottle is some different. So any kind of design which looks beautiful and not in the public domain, that's an design. Set of articles, cup set, sofa set, spoon set, all the different articles are there. So anything which looks new, beautiful, that's an design. Sanitizing machine. Earlier we are not having, but everyone knows this design is registered. Many pharma, you can take, you are from pharma, so I've taken the different examples that ampoules, this ampoule is different from this ampoule, this. So all three designs are different. This capsule design is different from this capsule. This syringe is different from this and this. So anything which looks beautiful, if it is designed new, not in the public domain, go for the registration. You will get grant from Government of India. Again, if it is textile and jewelry, dress designs, earrings, bangles, watch. I am using Timex watch. You might be having Titan watch. The design is different. So each kind of design is totally different. Let us see another kind of intellectual property called trademark or brand name. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the goods, to distinguish from the goods of others, like Ajanta Pharma. Again, Tata, Bata, Maiko from Jalna. So different industry, there are name is registered. That's called trademark. It advertises goods and services, protect the innocent public from buying the goods of second-rate quality. For example, we know Pond's powder. Spelling is P-O-N-D-S. Somebody comes with P-O-U-N-D-S. That is second-rate quality, but we never check. Therefore, we should have a check what exactly the mark is registered. What is that? Then you will never be cheated in the market. Adidas shoes, Puma t-shirts, Puma shoes, all are second-rate quality in the market. R with encircled is a registered trademark. TM is they have applied for the trademark yet to get the registration. Term is 10 years. You can extend for more than that. Geographical indication. Place names used to identify source of origin, quality, reputation, or other kinds of products like Darjeeling tea, Kanchipuram silk saree, Nagpur oranges. These are the different origins from the different location. They got the GI. Let us see another kind of intellectual property called copyrights. Copyright is a bundle of rights provides to right holders to restrict from unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, and software also. The term is life of the author plus 60. Therefore, you might have heard many singers sing the song recorded, but still they are getting the royalty because the time life of the copyright. For example, I have taken the common example to make you understand how we can protect different intellectual property with a single product. I have taken Sony. You can take any PCR, RT-PCR, any product. Sony, first time when it came in the market, and remote control mechanism. It means sitting on the sofa set, operating the television technology. So they got the patent. How it looks with the color combination, design. They got design registration. Sony name in this fashion, they got trademark. Instruction, which are there in the box of TV, got copyrighted. So single product, you can protect with the different IPR so that other competitor who involved in the manufacture of TV will never ever copy your technology and they are in the market. For example, Samsung. Samsung is also playing in the market. Sony, both are earning their profit, but they are not copying each other's technology. If they copy, Sony will sue them in the court. Therefore, in case of pharma, medicine, or any kind of industry, If you are getting product for your formulation or medicine, is a product patent. Process patent. If you are taking design of that capsule medicine, design registration. So our instruction how to use your capsule or medicine, that's copyright. So please try to apply each IP which is applicable to your product, process or design of that. This I have taken an example to make you understand what is trade secret. Trade secret is one kind of intellectual property, never been disclosed nor published. It maintained secretly. You might have tasted Domino's pizza. Another pizza is homemade pizza. Another pizza is the pizza which you can get in any other common hotels. If you taste 3 pizzas, the taste of Domino's is totally different from others because they're adding some trade secrets. Therefore, we don't know the formula of Coca-Cola. We don't know the formula of Maaza. These are the, if you eat the Sahuji of Nagpur is different from your Aurangabad meals. Pav Bhaji of Mumbai is different from Nagpur Pav Bhaji. Mysore dosa taste is different from what exactly we are eating Mysore and what we are eating in other Udupi hotels in Aurangabad or in Nagpur or anywhere. So something tastes different, we don't know that because of trade secret. Like Nokia, Samsung, each one got different mobile. You might have seen the picture, Marathi, De the car. In that, Makarand Anaspur has invented one vehicle part that was sold in the Mumbai for his taking the harmonium, and it was already registered by his friend. Therefore, he has got crore rupees back as a royalty for that product of new. That is called inventions. What can do with the IPR? Why government is making to know about the IPR? Why they are telling us to conduct more and more IPR? Because if you are a science graduate, you can become a patent agent. Every year, our office calls for the patent agent examination. There are 2 papers. One is objective, second is a descriptive. If you qualify, you will get a patent agent number from the government of India and you can practice it. If you're a common graduate or humanity graduate or law graduate, you can become trademark agent or copyright agent. Again, if you are having knowledge of IPR, you can work in the IPR policy, IPR cell of central government, state government, company, university, colleges, everywhere nowadays IPR cells are there. You can work there also. Again, you can work in the NGOs who are become facilitator to inventor, the government of India to the inventor. Again, you can work in the IPF firms in Aurangabad, Pune, Mumbai, many IPF firms that you can work. If you are MS in chemistry, biotechnology, microbiology, physics, or any branch of B, you can join to the government office, depend upon the advertisement. Again, there are 2 papers, one is objective and then descriptive. If you qualify, definitely you will get a job in the government of India. You can also, you are a scientist, but you can also be inventor. How? By simple approach. While carry out research, identify some problem, solve that problem, definitely you can get the patent. For example, during Ganapati Puja, now started, we bring many flowers, garlands, Naivedyam. What we are doing after 9 to 11 days, we are throwing in pond, river, or lakes. Ultimately, we are polluting the aquatic life. It is affecting the aquatic life of the flora and fauna. Once the government came to that smelling the pond or river, they throw some chemicals. It is directly affecting the aquatic life. Why can't we, being the pharma, biotech, or micro, can think a method, a biological method or herbal method for treatment of pond water or river water? It never causes any harm to the flora and fauna. But we are not thinking. If you think in this fashion, definitely we can do something innovative, something good we can do. For example, production of biodiesel from your campus waste, production of methane from your campus waste. Or if you can take the topic like production of beverages from sugar molasses or grapes, simple topics. Or a herbal composition for psoriasis, herbal composition for jaundice, herbal composition for dandruff curing. So you can, there are many shampoos in the market, you know, Vatika, Clinic Plus, Doe, many shampoos are there. But if you are really working on some medicinal plants, doing herbal composition for treatment of dandruff, if you are showing more effective efficacy, then definitely your shampoo is also patentable and you can come in the market. But you have to prove how it is more efficacious than the other shampoos like Vatika, Clinic and all. What is patentable in India? All processes and products are patentable in India, which are new, novel, and having inventive step capable of industrial application. Now, how we can say the research work is new or novel? When it should not be published in India or elsewhere. It should not be in the prior public knowledge or prior public use within India, are claimed before any specification in India or elsewhere. Then, if it is not published anywhere else, then we can say the subject matter, the project, what you have carried is a new, qualifying the definition of novelty. Again, when we can say that your research work is qualifying the definition of inventive step. Inventive step means feature of invention that involves technical advancement as compared to the existing knowledge or having economic significance or growth, and that makes invention not obvious to a person skilled in that. It means, for example, earlier telephone was AG bell, technical advancement is mobile phone. Having economics, earlier simple Nokia mobile is more than 5,000, now 1,000, 2,000 up to 40,000. Economic significance, or both if you are qualifying, definitely it's not obvious to a person skilled in that. Again, then that makes invention not obvious to a person means, for example, process of preparing a herbal tea comprising steps of, we know very common, it's very obvious, but to get in patent, it should not be obvious. It means you should require an experimental skill. Definitely that is patentable. For example, I am from Maharashtra. We used to make herbal tea that is an lemongrass or kavlacha mulya. But the fellow who is in Karnataka, they are using ginger as a tasting it for herbal tea. The fellow from Gujarat, they are using cardamom for the tea. The Andhra fellow who visit to Karnataka, Maharashtra and Gujarat, it's very obvious to him to make use of these three ingredients like cardamom, ginger or lemongrass because he has saw that. So to get a patent, it should not be obvious to a person in that. Means you should have some experimental skill. Then only you are qualifying the definition of inventive step. And the requirement, how something surprising result, solution to a long-standing problem, fulfilled of a long-felt need, are a great technical purpose. If you are doing all these things, definitely you can get a patent for your technology, process, composition, or any kind of work. Another requirement is it should be made or used in the industry. So definitely your applications are used in the industry. We'll take in one example to make you understand the herbal. See, we know the Parkinson's disease. This invention relates to a preparing of plant-based Ayurvedic formulation for the treatment of Parkinson's disease. At present, there is no specific and proven Ayurvedic medicine for Parkinson's disease. Therefore, I have taken this project as an undertaken to make use of an herbal plant to treat the patient who is suffering from Parkinson's. This is my field of the invention. What is the priority? Currently, there are many medicines which are synthetic, allopathic are having side effects. Therefore, I'm selecting this plant. Why? Because it's having no side effects, such as gastrointestinal, nausea, androgynia, or many other things. Therefore, I want to give this medicine to the public, which is free of side effects. This is my background. What is the main objective? My objective is to provide plant-based Ayurvedic formulation. Another object is to provide an effective tonic. Again, it's soluble also. So I'm telling all the positivities view of my composition or my medicine. Then again, what exactly I'm doing? I'm selecting the ripened seeds of Mucuna pruriens plants, bark or velvet bean or fruit of that, pluralizing that, again, mixing with 80 to 90% with some other formulations with antioxidant and stabilizers. So anything, if you are doing composition, you require main extract of the plant, then stabilizers, saccharides, antioxidants are required to make a composition or medicine in the form of herbal. So this is the way of making. Then detail I'm using, what exactly I'm doing. That is called detailed description of invention. You have to write 1 or 2 pages, how I am doing. Then how I am preparing, process of preparing plant-based Ayurvedic formulation for treatment of Parkinson's comprising steps of no full stop should be used before completion. Selecting so and so plant, comma, polarizing seeds of so and so plant, mixing powder with the so and so and getting the product. So this is a way of writing the claims for anything if you are doing. This awareness program, so I cannot go in detail, but I can overview that how can you write the claims. Process of preparing so and so is seed powder is of 90%, that antioxidant 5%, stabilizer is 5%. The process of preparing plant-based Ayurvedic formulation for treatment of Parkinson's disease as claimant, wherein said antioxidants are vitamin C, E, whatever we are using in the composition, you have to mention. That is called multiple dependent claims. Now, lastly, dated and signature of the applicant, or if you are going through agent, you can do that. Really, if you are doing compound invention, then you can claim this and Pfizer patent application, compound of formula so and so, wherein A is so and so ring, fused, saturated, whatever the all things you are substituting is called Marcus type of claims. If you are claiming the process of preparing something, then it's a Ranbaxy application. Process of preparing trifluoromethaноsulfone ester of ethyl 2-hydroxy 4-phenyl of formula 1, reacting with the formula 2 and coming with the products. This is a way of writing the process claim. Now, if you are claiming the composition, that is a simple application, pharmaceutical composition, which composition azolistine or salt thereof. He is claiming compound as well as salt, so that its competitor like Ranbaxy, Sun Pharma, Glenmark should not come with the same composition or salt thereof. So he's protecting his boundary of that invention. And for what it is suitable for nasal or ocular administration. And he's telling it is in the form of aqueous suspension or solution. Composition as claimed 1 or 2 in the form of aerosol, ointment, eye drop, nasal spray. So all the forms of that medicine he is claiming, wherein the composition is claimed 1, which is in the form of powder also. Means he is not allowing any other form to his competitor. He is claiming compound, salt, and all the possible form of that composition. Powder, inhalation, oral, ocular, all the forms. So your competitor will not come with this. Therefore, this is a way of protecting your invention. Now, you learned about the different patent, design, trademark, and copyright. Now, how to file the patent application in India? Who can file? Any person, natural startup, MSME, anyone can file the patent application. There is no age bar limit. How can you file? Physically, you can file in the patent office, going to the office, or you can file online also. We have given the facility of filing the online application. There are different jurisdictions. As you are from Maharashtra, Mumbai is your jurisdiction. What are the documents required for that? Covering letter indicating the list of document, application form 1, proof of right, that is form 9, paragraph 9. In form 1, you are supposed to sign, who are helping you to carry out the research. Provisional or complete application filing, you have to mention on form 2. Provisional means as soon as the idea get in mind. Today you are getting idea that I should produce biodiesel. Then it's called provisional. But after completion of research work, with fulfill product with the claims, if you are filing, that is called complete application. Form 3 is required whether you are filing in foreign countries or not. If not, then don't file. If you are filing foreign country, what is the state, number, status you have to mention. Form 5 to declare up inventorship, as you are adding your friend's name in the paper publication. Same, you can add your friend's name here, but here everyone will get the equal right. Please keep in the mind. Until unless you file Form 18, we never examine your application, so it's must. Filing fees for all the teaching institutions, 80% fee concession, even though for natural person 1,600, for company or others 8,000 for the patent up to 30 pages. More than that, per page different fees are there. Please check the website, details given on that. Form 18 is 4,000 for natural person, 20,000 for the company and others. Form 9 is not compulsory. If you want to early publication, then only. You can get patent within 1 year by requesting as an expedite examination as per Rule 24B of the Patent Rules 2003 as amended. Form 18 is must to file that. And who can file? If you are choosing, you are filing PCT country, in that you are choosing India as an international searching authority, then or applicant is a startup, or as per the Untitled rule, one of the applicant can be ladies or government organization or institute can also file. The fees is 8,000 for individual, 60 for the company. If you want to get forms online, please visit our website. If you want to file online, ipindiaonline.gov.in, you require digital signature or e-signature to file the patent application. To file the design application, you require digital signature. To file the trademark, you require digital signature. To file the copyright, you don't require any signature. Log in, create your own ID and password. How we are granting the patents in India? Once you're filing the patent application, we are sending for it digitization. Then we are screening and classifying depending on the subject matter like chemistry, biotechnology, engineering, which field it is. We are using international patent classification system that is called IPC. If you are requesting for early publication, we are publishing within a week or a month, otherwise 18-month publication. Once it's published, anyone can oppose, that is called pre-grant opposition. Once you are requesting for examination within 48 months from the date of filing, then we are taking for the allotment to the examiner and control. They will examine and they give the gist of objection that is called first examiner report. If you are filing the reply within 6 months or unable to file, then you can take it 3 months. Within 9 months, by hook or crook, you have to file the reply. If your reply is okay, persuasive, then it will be granted. If reply is not okay, it will be rejected. If you are granting or rejecting, will be the speaking order, or otherwise we will give an extension by if you are requesting on form 4. Again, if it is granted, we go for the publication that is called post-grant publication. After that, only interested person can oppose. Starting, any person can oppose, but after grant, only interest. For example, Bharat Biotech of Hyderabad is developing some vaccine. Then Biocon of Bengaluru can oppose because they are in the same field like pharma field. They are called as person interested. Once the option filed, grounds of opponents are forwarded to the applicant. Applicant give detailed reply on that. If applicant and opponent request for the hearing, we conduct the post-grant hearing. Simultaneously, we condition opposition board that they will give the recommendation whether we have to grant or reject the application based on the opposition grounds. In the hearing, we call both opponent. Opponent will take the hearing and grant the take the hearing. If applicant is able to fulfill all the grounds of opponent, then it will be granted. Applicant fails to overcome the ground of opponent, definitely rejected. If you are rejecting or granting, we give the speaking order so that you can appeal in the higher courts. What is the role of patent system? Encouragement or improvement of technology. X-ray to CT scan machine, AGBL to mobile phone. How much improvement you have done? Providing reward as an exclusive right for disclosure, making profit or earning royalty through putting the invention in practice. Many professors take the patent, they keep as a file record. What is the use of that? It has to work. It has to get royalty from that because the definition of intellectual property and IP as it get an in return with that means it's an intellectual property and asset like any other form of property. It means like gold, flat, it's having value. Therefore, it has to work. Transferring into public property after expiry of term or once patent deceased. Only 20 years right you are having, after that it will be in the public domain. If you got the patent unable to renew that, then it will be seized, then anyone can use your patent application. What is the role of patent system? Now, what can we do? Because we got all about the IPR, what is patent, what is design, trademark, copyright and geographical indication, how to write the patent application, how to write the claims also. Now, save the benefit of patent system in school, colleges, universities. Utilize the resource through organized R&D activities. Capture the global market judicially, earn the profit through the protected market only. Don't do something you are inventing, somebody may copy your invention. So first invent, go for the patenting, then go in the market. There, then no one can use or no one can copy your inventions. Thank you. Now session is open for the discussion. Please feel free to ask any questions regarding to the IPR.
Hello.
Yes, sir.
I have taken some questions from the audience during the session only.
From audience.
The question,
Please share the feedback link so that they will get the certificate. Put in the
Yes,
chat box. Dear participant, you are all requested to fill the link, then only you are getting the certificate. Otherwise, coordinator is not responsible for that. So please fill the link. Sir,
Sir.
please share the link.
Sir, we need to find the link. Yes, sir. Yes, sir. So,
Yes, please ask the question, sir. Anyone can read from the chat box.
okay. So, very nice and informative session, Dr. Bharat sir. Basically, you have covered all the aspects and basics of IPR, including, copyright, design, the basic difference between all these terminologies which we encounter in the academics. Since a majority of the participants are from the academics, so everybody is cautious about how we can go for patent application, whether we whatever the work we are going to carry out in the laboratories that can be patentable or not. So number of questions are always there in the mind of academicians. So with that view, you have covered almost all the aspects, the difference between the different terminologies, that is IPR, copyright, design, as far as their applications on the Indian platform. Now, some questions that have been given by the participants. So, regarding patent examination, you have mentioned. So, what preparation being the students who are taking who are there in the graduation and post graduation, what type of preparation they need to do as far as patent examination is concerned?
Yes, sir. There is Patent Act which in the upload in the our website also. Patent manual is also. You have to know about the what is Patent Act and manual of that. In that they will call simple about the one paper is of multiple choice question paper, another descriptive. In that Patent Act is sufficient for any B.Pharm fellow or any science grad to write the exam.
Okay. So
You
another
can check the question papers star website. In our website there are question papers. You can download the previous year question paper and can appear. Every year we are conducting the exam. They announce in the month of December and my exam will be in the month of May or April, like that.
Okay. So another question, sir, regarding international patent application. So if any researcher want to go for US patent, so what procedure he needs to follow as far as the application is concerned?
Yes. If you want to file directly in USA, you have to take the prior permission from the India under Section 39 of the Patent Act. Or if you want to file in India, then you can designate the PCT country, USA, and you can file there only. You can file as a convention application or an PCT application. This is left to you. PCT means you can single application, you can file in many countries wherever you want. A convention application means single application, each country you have to go and file. So this is different with PCT. So anyone can file the PCT application by filing from India or directly US by taking the prior permission from the country as per Section 39 of the Patent Act.
So another question, sir. So for application of patent, so as far as women researchers are concerned, is there any special, we can say, provision for women researchers?
There special means they can file as an expert examination as per Rule 24B. She is having considered in the fees and all, so she can go for that.
Okay. Okay, so these are some of the questions that have been asked by the participants of the session. So,
Thank you, sir.
Abu,
Thank you.
Abu sir. Okay. So, I think the questions are over and we can conclude this session, sir. Thank you very much, sir.
Thank you, sir. Thank you so much. Thank you. Please don't forget to fill the link. Share the link in your chat box. Then only you are getting the certificate. Thank you. Thank you. Bye bye.
Thank you, sir.